As attendance, Leonard Loza, chairman, is here. Stephen Esposito is here. Catherine Fuller is here. John Gatto is here. And Amy is not on the Zoom portion, but she is in attendance via the telephone.
I'm here.
Okay. Next item on the agenda, number 3, are public comments. If anyone would like to speak at that particular time, please raise your hand and our secretary, Alana, will recognize you.
Are we doing that first, Len?
Yes, we're going, well, that's the order that they're in, the public comments.
Oh, okay, sorry. I thought the administrative business was before that. Is it not?
No, it's on the line above it.
Oh, okay. So I know Barbara is here to speak for public comment. Barbara Peterson?
Yes. Shall I go ahead?
Yeah, you go for it.
Okay. Good evening. I want to thank you, Chairman Loza, and all the ZBA members for hearing these new comments on the Trans-Hudson variance requests. They were written not by me, but by Bob Hughes, former Town of New Paltz Planning Board Chair and former Town ZBA Vice Chair and Acting Chair. So I am Barbara Peterson, a Town of New Paltz resident for the last 34 years. I'm reading on behalf of Bob Hughes, who is unable to be with us because of medical challenges. And I should say I fully endorse his statements. So here goes. In its review, the ZBA must determine whether granting these variances would be detrimental to nearby properties and to the Gateway District, the primary entrance to New Paltz, an area that is not fully developed and contains numerous sites likely to be built upon or substantially renovated in the near future. Because they anticipated the transformation of this part of the town board prioritized rezoning it through an amendment to the town's comprehensive plan. Realizing the unique opportunity to direct the coming changes in a manner consistent with the desires of the community. That the town decided to begin in this neighborhood and not in another does not, as the applicant has suggested, in any way delegitimize the effort. While the applicant emphasizes that their proposal is almost entirely zoning compliant, the one point of non-compliance, building 1 story instead of the required 2, cuts to the heart of the code. While it is true that construction of some single-story buildings preceded the creation of the district, the new zoning guidelines assure that future renovations at these locations will be undertaken in conformity with the community's resounding preference for a change from the former suburban strip model. The town is not and should not be bound forever to simply replicate the building patterns that have come before, especially when their well-known flaws have made them undesirable in the present. Indeed, it is worth noting that Tops, Walgreens, and Burger King do not fall within the Gateway District and so should not be invoked as a basis for comparison. Granting the variances would deny the town and adjacent properties of a major benefit, an opportunity to realize a vibrant Gateway District that substantially improves upon the kind of sprawl that was allowed there in the past. Unlike in most instances, less density here is a negative change. The code stands to assure that future changes will occur cohesively, achieving village-style, pedestrian-friendly, efficient building as desired by town residents. These major variants depart from that vision and instead harken back to the auto-centric model of suburban sprawl. They benefit only the applicant and would be a loss to the community. Today, New Paltz is renowned for the village's portion of Main Street, the area around P&G's and Elting Library, not the town's portion, which could be anywhere. With this zoning, the town is trying to make its portion of Main Street more like the village's, allowing the applicant to construct single-story strip-style buildings would clearly have detrimental impacts on this effort. diminishing the value of nearby properties and the Gateway District. Finally, this is in Bob's words, in Bob's many years of service on the Planning Board and ZBA, the input of fellow boards was always taken extremely seriously. On the issue before you tonight, the Town Board of New Paltz voted unanimously that there is a potential adverse impact to surrounding properties and the neighborhood of not applying the two-story zoning standard to the project. Further, the Ulster County Planning Board, a body generally motivated to promote development, issued a clear recommendation against the full variance request for granting instead only the minimum necessary relief, a mix of 1- and 2-story buildings. I hope you will heed the clear resolutions from these boards who, like you, have studied the application carefully and measured it in relation to the long-term priorities and well-being of the community. And I thank you respectfully on behalf of Bob Hughes.
Thank you, Mrs. Peterson. Is there anyone else that would wish to speak during the public comment time?
Yes, Dan is here to speak.
Lynn,
Yes, Joe.
I just want to remind the speakers, the public hearing on this application has been closed.
Yes.
So any of the comments coming from the floor tonight that are addressed to this application, if they are, they really should not be heard. And if they're made, they are not part of the record upon which the board is going to render its decision. And I think that needs to be clear to the applicant and to the board. Public hearing has been closed. These comments, it's public comment period, but I'll rely upon the speakers to know and understand that they're not part of the record upon which the board is going to make a decision. And if they go too far, I'm going to suggest that the chair stop it.
Understood.
Thank you. Thank you for your advice. It is understood. And I'm hoping that all of the applicants or anyone that wishes to speak, if you're going to speak this evening about Trans Hudson, understand that the public hearing was closed at the last meeting. There was an opportunity to submit letters. No letters were received. So there are no letters to become part of the record. I would ask the remaining people to try and keep your briefs short, if in fact you're going to speak. Thank you. Next.
Good evening, everyone. I will share a brief letter from 3 New Paltz residents, Lee Bell, Krishnamurti Ravi Shankar, and myself. We're all New Paltz residents.
Excuse me.
Oh, sorry.
I'm going to take Mr. Moriello's advice. Those letters were not submitted. They will not be heard for the record.
Yeah, that I understand. And
Okay.
I didn't.
Please don't. Are you going to read me 3 letters or 1 letter from 3 people?
One brief letter from 3 Town of New Paltz residents.
Go ahead.
Okay, and my name is Daniel Schneeven. I'm also a New Paltz resident. Over the past few months, you have reviewed statements from numerous community members, the New Paltz Town Board and the Ulster County Planning Board, detailing the detrimental neighborhood impacts that stand to occur should Trans Hudson's requests for the 2-story variance be granted. While we won't restate the entire list again, these detrimental impacts include preventing the creation of a district that would be characterized by the best aspects of our celebrated Main Street: smart density, the efficient use of space, and walkability. Imagine how different Main Street would be if all the buildings were single-story. The density of that district is what makes it what it is. When it comes to the application before you, the requirement for 2 stories is really all that stands between the Main Street model and that the community so clearly desires and a de facto throughway rest stop. The applicant has urged you to grant this variance because they claim it's the only path forward at this location. They have insisted that 2-story zoning compliant buildings are a non-starter at this location, and so therefore the variance's benefit to the applicant exceeds the detrimental impacts on the Gateway District. While their arguments may sound persuasive, we cannot forget that for nearly a year, the applicant similarly insisted to the Planning Board, the Town Board, and finally to all of you, that a drive-through restaurant was essential to the financial viability of the project. For example, In their original application letter to this board dated January 26, 2021, they claimed that food establishments would not lease a space that did not include a drive-through, and that this would be a permanent condition. In other words, not one limited to the duration of the pandemic. Community members provided evidence to the contrary from sources like Forbes magazine, and yet the applicant continued to hold that a drive-through variance was a necessity. Suddenly,
Daniel,
yeah,
Daniel?
Yeah.
Are you aware of the fact that the drive-through application has been withdrawn?
Yeah, that you timed. That's exactly what I was about to say. I said, yeah.
Mr. Chairman, I'm sorry to interrupt. Isn't the public hearing closed on this matter? I'm not sure why
Public
we're
hearing is
hearing
closed.
comments from the public.
This is general publics from the comment.
And
Go ahead, Daniel.
I'm almost done. Yeah, thank you. I said suddenly, and this was a welcome surprise, as the chairman just alluded to. The drive-through request has been dropped with no explanation given. Regardless of why this happened, it is hard not to now question whether the justifications the applicant has advanced for the remaining variances are any more real. Should they be taken at their word, for instance, when they insist that it would be impossible to receive financing for a building in which the second story would be rented out for professional offices or studio space? Otherwise, seemingly,
I'm sorry, but this goes far beyond a brief letter and public comment. This
Okay.
is lobbying in favor of a particular position. This hearing has been closed, and I'm really going to suggest that the speaker has made his points and that no further public comment like this go on. It's unfair to the applicant and it's unfair to the board.
Mr. Moriello,
Okay.
with all due respect, and you've been attending these meetings, obviously your experience far exceeds mine. At every board, every town board, every municipal board in our town, it's standard practice for public comments to be received on any topic, so long as they're brief at the beginning of the meeting. I realize the public hearing is closed, that these will not be added to the record. However, I think it's a undemocratic measure to not maintain the custom that is standard across the other boards in the town. I have about a paragraph left.
Quickly.
I'm really not going to get into a debate about it, but the other boards in the town board, the planning board, operate under different legal requirements than the zoning board of appeals. This is a quasi-judicial body that is charged with the duty of rendering a particular decision in a particular application according to the issues as they're framed by statutory law. And it is unfair to expect that, notwithstanding that a public hearing has been closed, that I'm still going to get all of my arguments in, if not on the record, at the very least for the board to hear and consider, because it's almost impossible to ignore it. And Dan, I'm going to ask your cooperation to understand that and the protection of the record in this matter in the event that there is a judicial proceeding which follows it and puts it under attack for this reason.
I understand, Mr. Moriello.
Please understand.
I appreciate your.
Daniel, thank you. We are going to close your portion of speaking. Is there anyone else in the audience that would like to speak on another topic other than Trans Hudson?
No one else messaged me.
Okay, thank you, Alana. I entertain a motion to close the public comment period time.
I so move. This is Amy.
Or Amy seconded, rather. All those in favor signify by aye. Aye.
Aye.
Public comment period closed. Next is the administrative business. By now, everyone should have received their copy of the May 12th minutes. I reviewed them. I didn't find any changes that needed to be. Did anyone find anything that I may have missed? No. Okay. No. Okay. Entertain a motion for the approval of the May 12th minutes.
I make a motion.
Second that. All those in favor signify by aye.
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 Motion carried. A quorum check for the next meeting. is Wednesday, July 14th. I will be there.
Yes.
John will be there.
Yes.
I'll be there.
Stephen and Amy will be there. Joe Moriello will be there. Catherine? And Catherine will be there. So we'll have a full board at the next board meeting. Okay. That's
field day.
yes. Okay. Entertain a motion for a continuance of the public hearing for 19 Outlook Farms. Looking for a second on that, please.
Do we need to second that? Didn't we
Thank you, Amy.
agree to continue it?
For continuance of the public hearing.
Do we need a motion to do that?
I just made that. If you'd like to second it, that would be great.
Sure.
Okay, all those in favor signify by aye or raise your hand.
Aye.
Aye. Okay, motion carried. Public hearing is open with regard to 19 Outlook Farms. Is there anyone there to speak, Alana?
I didn't see anyone in the chat, but if anyone else is here and wants to speak on it, they
Okay.
can do so.
Oh, wait a minute, you know,
I'm here as the applicant representative. Would you like me to speak now, or we want to go into the review after?
can I ask a question? I've got it says this meeting is being recorded on my screen, and I thought I saw Stacy, our building inspector here. Is she here, Alana?
Yeah,
Oh,
she's here.
Yes, could you please add her name to the attendance list? I just saw her name. How do I move that thing?
Yeah, I
There
have her
it
on
is.
there. Don't worry.
All right, I found out how to move this thing.
How did you?
Great. Okay, I didn't add, Okay. Hold on one second, if you would, Mr. Schmidt. The wetland inspector went out and reviewed the property. He submitted a report. Did everyone have the opportunity to read that report?
Yes.
Yes.
Any questions or comments with regard to that report? Yes,
Yeah.
John?
I just want to make sure I got everything there is. What I got was a memo from the wetlands inspector with a couple of photographs on it. That's it?
Correct. And it was,
I was present.
Okay.
yes. So from the map that was presented to us, it appears as though that the presented location of the pool is adequate within that adequate outside of that 100-foot buffer with regard to the wetlands that were there.
That's correct.
Is that correct, Stacy? Okay. Okay. Chris, did you have anything you wanted to say?
Well, I just wanted to, I didn't know how we were going to proceed tonight with, that there were several questions at the last meeting, one of them being the wetland location that I wanted to address. I believe there's a few board members that had also asked about how we, arrived at locating the pool in the side yard. So if we want to review that now, we can discuss.
That's
items.
where the way with which you located that pool is obvious from the maps that were presented to us. I mean, it's pretty simple and straightforward right there.
Yeah, I mean, the location of it is straightforward, but the questions were, why did we not locate it in other locations? So I didn't know if it would be beneficial to anyone who wasn't at the site that saw the steep slopes that lead up to the wetlands as to why we weren't on that side. I have a few photos from that area as well.
Does anyone at the presently at the board that needs to have an answer questioned, please raise your hand.
I have a question.
Amy?
Question. Since I'm on the phone, I can't tell who is speaking. Would you identify yourself, please?
Oh, I'm sorry, Amy. This is Christopher Schmidt with Neve Group. I'm representing the O'Connors for the.
Thank you. Thanks.
You're welcome.
John,
So-
I saw your hand. You had a question?
I do, yeah, a couple. Number one, I very much appreciate the concern given to the wetlands boundary, and that's great. When I saw the inspector's report, it's hard for me to tell exactly what's happened here. He gave essentially a 1-point report. He said at this 1 point, it's 25 feet distant from the wall. And you submitted a revised septic map that shows an entire boundary. It's not clear to me how you got that from what the wetland inspector reported.
So he had made the assumption, we went back to where the original line was, and then he did a few soil samples, working his way out towards the house. And he stopped at what was about 25 feet closer to the house. And he said that it appears as though the wetland boundary has moved unilaterally from there to that section. He did test a few locations. He did not, map the entire length of the wetland.
Okay.
But it was his professional opinion that it had moved 25 feet. Therefore, we marked on our plan and updated that with the new, location of the boundary and the buffer zone.
Okay. I don't have any particular problem or objection to the new wetland boundary or the relation of the pool in relation, the location of the pool in relation to that boundary.
Okay.
Do any board members have a question for Mr. Schmidt or of Stacy?
Can I also ask what has changed? What's different? Why is the revised septic plan that was just sent out, in addition to showing the revised wetland buffer boundary, it's now got an additional septic field, a proposed septic field, a third one for this property?
No, so what we did was we went out and field located the septic. We left in the original locations that were on file with the health department in the town. But Stacy was out there. The main one that we're concerned about, or where the actual septic is now, not necessarily the plans. And it was quite obvious and visible where the septic for the barn is, as well as where the house is. So we marked those locations on our plan and then did the appropriate health department setbacks off of them. We left on the original fill area. To be honest, I've checked with the health department in the town, and it's just the only records that they have of the subdivision plot. They didn't have the as-built formal plan, so we did a field location on there.
Yeah.
And then we made that assumption of a reserve area below the existing septic for the main house.
One other question relating to the septics, and that is all the setbacks that you've delineated.
Yeah.
What is the basis for that? I looked and looked and looked in the town code, in the sanitary code, in the New York State sanitary code, the Ulster County. I couldn't find anything that said anything about a distance of a swimming pool from a septic facility or field. Can anybody help me there?
I'd have to look again to see where we pulled the information from, but it's a general rule from all Department of Health in different counties that it's 25 feet when you're above the leach field elevations and 50 when you're below.
Well, I'm not sure what weight I put onto a general rule that can't be pointed to on the books.
So, well, that's what I can find that rule and let you know what it is.
That would be helpful,
But I
because
think-
believe me, I looked, I wanted to see what it said, and I could not track it down.
Right.
Am I correct,
Okay, well, I'll
Joe?
find that.
We do need to make a decision at this night's meeting. This is the second month.
The public hearing hasn't been closed yet, Len, so
Okay.
the clock's
Okay.
not running. I don't know if Stacy.
No, if it hasn't been closed yet, then the clock's not running.
Yeah.
Okay.
I do not know what the 75A, the sanitary code, if there is a requirement there for a setback from a septic system. I do not know what that number is.
Yeah, it's the 75A New York State regulation lists required distances from wells. That's all. unless I'm completely reading it.
May I ask another
Well,
question? This is Amy.
There certainly is a setback. I don't know the code off, the call out for the code off the top of my head, but I would, there is
Can I ask
a
another
setback,
question?
and it's 25 and 50, and I can find the,
Dan, please speak.
yes.
It makes a difference in the whole discussion about where you can and can't put a pool.
I
Len,
understand
may
that.
I ask another question?
Say that again,
Sure.
Alana. I'm Amy.
I have another question. I don't quite understand the business about the wetland moving. If Chris is going to provide some information, some documentation about the setback, I'd also like to see information about where the wetland was and where it is now. That's not really in the memo that the wetlands manager provided.
Amy,
we just, yes.
this is Stacy. The original plan that they submitted showed the wetland as was delineated on the original subdivision maps. Okay. The new map that was submitted, was it this week, Alana? That you all received, that shows the wetland buffer, okay, with the update, okay. That's based on a field visit by our wetland inspector, okay? So it really hasn't moved much because I believe the wetland delineation that was done on the original subdivision map just marked the wetland, mark a wetland buffer. So you can see that it's pretty much remained the same. It's just now the map is showing a buffer, and that was based on, our inspection, the Mark Carabetta, the town's wetland inspector, and I was out there to, be a part of it. So, I'm well informed as well. I don't know if that helps you any.
Yes, that does. I must have misunderstood. I understood Chris to say that the boundary had moved, the wetland had moved.
Well, the wetland itself really didn't move much, but we're now showing a buffer because we have a local law. At the time of the subdivision, there was no local law, and it's not a state wetland. I believe it's a federal wetland. And therefore, for federal wetlands, there are no buffers. So at the time of the subdivision, no buffer needed to be shown because there aren't any required buffers from federal wetlands. Now that we have a local law demands a 100-foot buffer, and that's what we're now showing.
Okay.
Great, thank you. That clears it up. Thanks, Stacy.
Any more comments with regard from board members or anyone from the public with regard to 19 Outlook Farms?
Well, I think I'd like to address the septic setback again. John, like as far as the relation of this to it, are you assuming that there is no setback to the septic?
I have to assume that if I can't find any reference to it in any of the codes.
Okay, and Stacy, you're not aware of anything in the code that stipulates it? I know that there is a code. Again, I'm trying to find it right now.
I do not know. I do not know the sanitary code. We don't generally deal with the sanitary code. I can tell you that it would not be wise to put a pool right next to, or any structure right next to a septic field, for the simple fact of, you have leaching, you have maintenance, there are different things. So, it's wise to have some form of setback. As far as a required setback from the health department, I don't know if there is one, or what that number is.
Okay.
So we have an unanswered question. I guess we can do one of two things. You close the public hearing and vote on it, which probably would not be a wise thing to do. or the other opportunity is to continue the public hearing until that information is gathered so that we could make a response to that variance with a more intelligent decision based on the information it is provided. It would be wrong to grant a variance for something that does not comply. Joe?
I understand these setbacks were on every previous map. So, you know, I'm curious as to what is drawing the attention to them this time through. You know, it feels like each meeting we have one question that tends to postpone getting a solution.
Well, the applicant sent us a revised septic map showing a bunch of changes and new setbacks. It really brought my attention to the setback question. What's actually required?
Okay.
Joe, would you recommend we continue the public hearing?
I think in light of the question, Lennon, I think your point's well taken. If indeed there is a setback or setback guidance from the health authorities, I think it's right. The board should not grant a variance that wouldn't comply with those regulations. On the other hand, it shouldn't deny it if indeed there are some required setbacks that need to be adhered to. I realize it means another month, but.
Right. I mean, this is a phone call, and that's what I guess I'm trying to. I know that the setbacks are 25 feet and they're 50 feet. I don't know the specific code that calls that out. It's standard in all counties. You know, so.
Are you saying?
Well, you said earlier that was for a well, but now we're talking about a septic system. So it would be better to have it in writing because the zoning board doesn't have the authority to vary a sanitary code. That's a state law.
I can assure you of some information that I have knowledge of firsthand, that a septic system reserve area must be 100 feet from a well. How do I know this? Because I was 6 feet short in one of my rental properties and was forced to drill a new well. So the distance between a septic area and a reserve area, both must be 100 feet distance from a well. That much I can tell you for sure I know. The other information, I don't know with regard to a swimming pool. Stacy's advice was well taken. The last thing you'd want to do is put a pool next to a leach field with regard to problems of leaching, maintenance in the pool, maintenance in the leach field. So until we have a correct answer, and not to scold you, Mr. Schmidt, but in your line of business, you should have this information at hand and documentation to support it, which should have been submitted with the application. I don't believe this.
Can I make one suggestion?
No, I understand. You know, it's okay. So I can provide you that documentation, and I apologize. I wasn't trying to offend anyone.
Not at all. John, you had a question?
Yeah, is in the interest of moving forward, we're going to be here for a while. Possibly if Chris knows where to look, he can quickly locate this. He could phone it in later. The hearing could remain open until we come back to it this evening.
Yeah, would it be possible, if you're okay with that, Mr. Chairman, to give me about 5 or 10 minutes to locate the code?
By all means, we can give you that. Okay, so how do we do this, Joe? Stacy?
Technically, you're in the public hearing portion of the application, so you can leave the public hearing open and then move to application review. Right, Joe?
Yeah, I think you just basically take an adjournment of the public hearing for the purpose of acquiring the information, move to another agenda item if that's the board's desire, and then
Okay.
move back into the public hearing.
Okay, we will do that. Entertain a motion to adjourn the public hearing temporarily for 19 Outlook form submission. Need a second, please?
A second.
I'd second on the condition that we get this as an email in writing, a record, not just a verbal assurance that the information is there.
With the condition that that written documentation be provided through email?
Yes, maybe Chris could send an email to Alana, who could forward it to us.
That's not going to work for me. I have no idea how to open another item on this screen without losing everything.
Okay.
Oh, I can open it on my phone. Yeah, we could do that.
Whatever we decide, I would like to have some sort of written statement rather than just an assurance that this is enough space.
Okay, so let's do this. We'll place, who seconded that motion? Was it
That was
John?
me. I had a conditional second.
Okay, yes, okay. So we will entertain a motion to approve the motion as amended. All those in favor signify by aye.
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 Okay, so start digging, Chris, and we'll be back to you in a little while.
Excellent. Thank you very much.
Okay, thank you. All right, so. Okay, this is a. Okay, we are now at application review for 12 North Putt Corners Road. As I mentioned before, the public hearing was closed at the last meeting. No letters from anyone in the public were submitted. None of the comments made this evening will be part of the record with regard to a decision on the 12 North Putt Corners Road. So the public hearing is closed, and I guess now it's in the hands of the board. First thing I want to make sure is that everyone has had an opportunity to read the letter that Mrs. Alantis sent to us on May 5th, not the letter, but the paperwork. And if you had any time, it'd be great if you read it twice. Has everyone or anyone not seen that? I'm assuming everyone has seen it.
I'm sorry, just say again, what is it that you're asking us to read twice?
No, I'm asking to make sure that everyone received the May 5th letter or the documentation in response to the 5 questions with regard to the area variance.
Yes.
Okay. So I'll open the floor now for comment with regard to board members.
Lynn?
Yes, Joe.
If you don't mind, because I know this is an interesting case. It might be helpful, I think, from the standpoint of the record. If you want, I'll do it briefly, just to review the board's legal requirements with respect to this type of an area variance, okay? There was some questions that have come up in the past, and I'm going to refer to the statute. In granting or making a determination for a variance application, the ZBA, and the statute says, shall take into consideration the benefit to the applicant if the variance is granted, as weighed against the detriment to the health, safety, and welfare of the neighborhood or community by such grant. I mean, that's the determination to be made. Then it says, in making that determination, the board shall also consider, and those are the 5 questions that typically we will ask of an applicant, okay? So and there was some discussion about the benefit of to the applicant. I mean, that's why an applicant comes before the board for an area variance seeking a benefit, and they're looking for a variance from the way the law is written. So it is the benefit to the applicant weighed against the detriment, and not necessarily just to the way the law is written, but it's really the detriment to the health, safety, and welfare of the neighborhood or the community. So I would just want to get that
I
out there.
understand that. The letter that we received from Ms. Zelantis went through each of those questions quite carefully, and her responses were detailed and to the point. Now we have the short form application, which I don't believe is, I have to fill that out anyway. So we will need to ask those questions again. And Ms. Zelantis, if you would, please, a yes or a no. I realize that we have your May 5th letter. I would also like to, well, let's go through these 5 questions first. For area variances, the applicant should be prepared to address the following considerations at the time of the meeting. Whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance.
No, it will not, because there's.
Thank you. Whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than the area variance.
Len, if I may, I'm not entirely certain that the applicant must be confined to a simple yes or no answer. I think each answer may require, if it does, some brief additional information if they want to put in. I would ask Kathy to please be brief about it, but I don't know that they're relegated to a simple yes or no answer.
Okay.
Nor is the board when it does its deliberations.
I will be very brief. In response to the first question, no, there's no undesirable change in the character of the neighborhood. As we established, there are numerous surrounding one-story retail standalone buildings.
Thank you. Number 2, whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than the area variance.
No, there's no other feasible method as set forth in the expert evidence that we produced, and both from an outside expert and from my client who has been in this, and from who has been in this business for many years, and also from an engineer.
Whether the requested area is substantial.
It's not substantial. We're asking to do less density and a lower height than required by the code. It's the opposite of substantial. And even if it is substantial, the courts have held that when there's no change in the character of the neighborhood or no adverse impact on the character of the neighborhood, that it's still not a basis to deny a variance.
Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district.
No, it will not. It's a less dense development, and the proposed development fosters walking and bicycle transportation. It also provides for a municipal use, which is different from other developments. We propose to have a trail that will go through the property, as well as a municipal restroom and municipal parking.
Whether the alleged difficulty was self-created, which consideration shall be relevant to the decision of the Zoning Board of Appeals, but shall not necessarily preclude the granting of the area variance.
It's indisputably not self-created because the town rezoned the property after BFB submitted its site plan application and determined the economic feasibility of the project. But even if it were self-created, which it's not, that's not a basis to deny the area variance.
Okay, thank you. Joe, Catherine's letter of May 5th, I would like to include that into the record with regard to a much more detailed explanation of the 5 questions. Do you see any problem with that?
All of the submissions by the applicant, as well as the people who participated in the public hearing, are part of the record.
Okay.
So it is already in. You're certainly privileged to refer to portions of it as the board discusses each of maybe of the 5 areas and employs what the courts call a balancing test of those 5 issues.
Okay. Alana, you have a copy of that I can give you with the decision for tonight?
Yeah.
Okay, thank you very much. Okay, now I'd like to entertain questions from the board members with regard to discussion as it has been submitted.
I think the presentations have been very complete. I have no further questions.
Okay, that's Amy. John, any questions?
Sorry, no.
Okay, Catherine, do you have any questions?
I have a question for Mr. Moriello. Is there a definition of public health, public safety and welfare?
Well, in the sense that how it's been employed by the courts, Catherine, I think yes. There's, and having looked at it, for instance, when you talk about public health, safety, and welfare, the courts generally have viewed those things such as neighborhood appearances, if there's any adverse effect on property values, loss of tax revenues, a decreased amount of or enjoyment of neighboring properties, traffic hazards, not just that there will be traffic, but true hazards. So there are issues that go, again, to health, safety, and welfare, because that's the area that the towns derive their authority to employ zoning in the first place. So it's more than just, I agree or disagree. It's neighborhood appearances, adverse effect on property values, loss of tax revenues, decreased enjoyment of neighboring properties, traffic hazards, and other things that the board may employ. So that's the health, safety, and welfare portion of that equation in the statute. You could address maybe each one of those. I think it's more than just, does anybody have any questions? The board, if it's going to balance these issues, maybe the board members want to speak to, do they agree? Do they not agree? Do they argue with a particular issue? I mean, that's the whole deliberative process. Does that help, Catherine?
It does, thank you. It does.
Okay, Steve, do you have any questions?
No, I'm good.
Okay, I've written a paper with regard to some of my thoughts and comments, and I'd like to read that. The decision of this board is to weigh the benefit to the applicant against the detriments to the community with regard to the 5 questions asked on the area application. It is this board's decision. It It is this board's decision going to be a detriment to the health, safety, and welfare of the New Paltz community. The drive-through request has been removed, and the area variance is seeking relief from the second-story requirement as defined by the MSU Main Street mixed use and the BTU bulk cable use. This requirement requested for second story was suggested for affordable housing. We have heard from the property owner, Ari Friedlich, which stated that an interior stairwell for the entrance and exit and an elevator are not only cost prohibitive, but there is a large loss in the usable floor space on the first floor. As discussed at previous meetings adjacent to the New York State Thruway, there will be an excessive amount of noise from cars traveling plus exhaust fumes from engines, not really making this a desirable location for housing. This location is not in a residential area as defined by one person's commentary. Residential homes are almost a mile plus down the road. With regard to traffic, this application was front of the planning board years before the land for the fire station, police, and court was even purchased. This application is requesting less density than its initial requested in the initial submission. I have spoken with several landlords about housing over commercial space. Not one spoke positively about this. Noise was a continuous problem, was their first comment. Second comment was overflowing water from either toilets or sinks. As we have seen, the developer has met many of the 30 approximate requirements for the area in that district. There was an applicant at one time which was in front of the board for 55 and older housing. It failed. Affordable housing may be needed, but proper placement is extremely essential. The Ulster County Planning Board made a suggestion to build the second story for aesthetic purpose. This is not a practical cost. This is not practical and cost prohibitive. The question is, who will it benefit? I hope all ZBA members have read and perhaps read the May 5th submission by Attorney Catherine Zelantis twice in regard to the 5 area questions and responses. Comments from the public when we make our decision should also be considered. So that's for me. That's my take.
Very
And,
good.
Yes,
excuse
ma'am.
me? Yes, John.
May I also add, I'm sorry.
Yeah.
Okay, who's going to speak? Raise your hand.
I will speak.
can't. John, you speak. I can't see Amy. She doesn't have her.
All right,
face.
so I've also taken the liberty of trying to organize my thoughts. And if you'll bear with me for a few minutes, I'm just going to read what I wrote to myself so that I don't fail to make any of the points I want to make. It'll take a couple minutes to walk through it, but I'm taking this time to do it because I think I approached it very systematically and fairly and kept things in the proper perspective. So again, bear with me for a couple minutes.
The more information you can give us, the better.
I stressed to the ZBA the importance of keeping our focus on the specifics of the variance request. The law is very specific about what we need to consider coming to our decisions. The things we must pay attention to. First, the town zoning code. And in this case, there's no question about what that code says or what it intends. It says very clearly what the purpose of this zoning is in this district. We don't have to guess or speculate about what was meant. Second thing, the laws governing ZBA authority and the decision process. We have some very clear steps to follow and criteria that must be met in order to grant a variance. And the third thing is the evidence provided by the applicant to support their argument. Here, very important, we can only rely on factual evidence. Without facts, they are just assertions, opinions, and pleadings, which can't carry any weight here. The past history of the project is of no relevance to the ZBA in consideration of this variance. For our purposes, the project started on January 20, 2021, when the ZBA received an application requesting variances. Applicants argue that they have met a long list of zoning requirements in their revised concept plan, and they fail now only with respect to one requirement. But that is precisely why we must focus. It is only this one requirement that we are here to decide upon. Applicant argues that their proposed project will include a number of public amenities such as public restrooms, parking, extension of the Empire State Trail, enhancing the desirability of the project for the town. They have noted in oral presentations that they're confident that they will be able to obtain water and sewer connections from the village. First, these arguments are totally irrelevant to the question before the ZBA regarding the requested variance. These kinds of enticements have no place in the clearly defined criteria for granting variances. We're not trying to decide whether the proposed project may have certain features that we might like. This is completely beyond the scope of our task and authority. Furthermore, they should not be given any consideration for the additional reason that they are merely speculative. The applicant has no legal agreement in place with the village. They have no legal agreement in place with the Empire State Trail Authority. They have no agreement of any kind in place with the town regarding maintenance of any restrooms or trails. We have only their statement that they will basically cross these bridges when they get there. This should not enter into the decision process of the ZBA. Finally, with proper focus on the specifics of the requested variance, we can address the actual criteria that must be met following the procedures laid out in the law. Okay, first question, whether an undesirable change will be produced in the character of the neighborhood, detriment to nearby properties. Their response is to point out that there are many one-story businesses in adjacent zones, and they state that their proposal would actually have the effect of lowering the density and lowering the building height. Apparently, the applicant feels that these are desirable features of their proposal, but they fail to recognize the express purpose of the MSMU zoning is to deliberately create an area of higher density to extend the successful Main Street model of two-story structures in a walkable environment, less dependent on automobile usage. The town has said clearly that it wants to move away from the strip mall, shopping center, parking lot character from decades past. The applicant is arguing that their proposal will in effect preserve this character. Maybe this is counterintuitive to retail developers, but from the perspective of the town, a variance would have exactly the opposite of the desired effect and almost by definition would be undesirable. A few more points. The applicant is guilty to some extent of cherry picking the examples they provided of nearby businesses and structures. They note that all but one of the freestanding retail and professional offices in the adjacent zones are one story. This obscures the fact that that one is a very substantial medical complex, represents a significant, successful two-story presence at that location. Also ignores the fact that just across the street are two very substantial commercial buildings, one of 2 stories and another of 3 stories. Next question, whether the benefit can be achieved by some method other than a variance. In this case, I have no problem with what the applicant has said, and I don't disagree with them at all, where they said, we do not have any obligation to try to develop residential property here. We're not a residential developer. It's not what we do. That's not our project. That is entirely their prerogative, and they do not have to try to do that, especially, or follow any of the other suggestions that came from the public in the public hearing, even though it's clearly anticipated and encouraged in the language of the zoning. But they have no absolute obligation to do that. But in the previous letter that they provided from their consultant, asking about financial considerations, the question they posed to that consultant was only about what's the feasibility of retail in office. They did not even ask their consultant for an opinion about residential. They don't provide any evidence that they made any effort to conform to the town code by seeking to attract tenants where a variance would not be needed. Also about that applicant's consultant letter, they were asked whether second floor office or retail space would be rentable and at what figure. The applicant's own letter argues about costs of construction, likelihood of generating losses. but they provide not a single element of any financial analysis, and their own consultant, when asked directly, failed to provide a single bit of data or an answer to a direct financial question. Neither the applicant nor their consultant, despite their stated broad experience in the field, were able to provide a single example of a project that was impossible to complete because of concerns of retail tenants about second stories. It's one thing to say that some tenants are hesitant. Does that mean that all or even most of them are? We're left to guess about this because no studies were done, no simple surveys of relevant literature, no examples provided. Almost done here. This one is easy to me, I think, and very straightforward, whether the requested area variance is substantial. Now here, we're not talking strictly about building height in feet, where maybe an applicant wants, for example, to go to 50 feet rather than 45. We're talking about a specific requirement to have a minimum of 2 occupiable stories. And the applicant wants only 1. Is that substantial? The difference between 1 story and 2 is an increase of 100%. Put differently, the difference between 2 stories and 1 is a decrease of 50%. Looking at just the numbers, the difference would have to be called substantial. And it's not necessarily true that less is better, as the applicant keeps trying to say. It's a substantial difference, maybe in a different direction, but it's substantial. And it's more important that the difference isn't merely one of height. It has a specific purpose of encouraging a particular type of environment, one that deliberately has higher density, more of a transitional village character. So the applicant's arguments there are I'm just going to leave it as misguided. Whether it has an adverse effect on physical or environmental conditions, again, the applicant argues that it has the effect of decreasing the density, which again misses the point that the stated purpose of the requirement is to promote a neighborhood with higher density, using the same amount of space by more people. And to completely defeat this purpose with the requested variance would have to be considered an adverse effect. So the applicant refers to previous history with the town planning board. As noted previously, any such interactions are beyond the scope of our consideration. The applicant quotes one individual planning board member expressing enthusiasm for the proposed project. Personal preferences of any individual, whether on the planning board, the town board, or the ZBA, can play no part in coming to a decision here. It's not what any individual likes or doesn't like. It's all about the strengths of the arguments and the factual evidence provided to support them, and not about the project itself, but about the specific variance under discussion. Whether the difficulty was self-created, the applicant has made a point there, which I won't necessarily dispute. So in summary, I am going to recommend denial of the requested variance, just as the applicant has no obligation to tailor a project to accommodate suggestions from the public. The town has no obligation to tailor its zoning code to meet the desires of any particular applicant. As always, New Paltz welcomes development. All we ever ask from this applicant or any other is that they bring projects that conform to our code. Sometimes the ZBA can justify granting requests for variances, and our purpose is to provide some reasonable flexibility on a case-by-case basis. I think I have tried to make the points that I'm trying to make, and I will leave you with my overall impression is that although we have heard a lot about what the applicants would like to have, I'm somewhat shocked at the actual lack of hard factual evidence for supporting any of their arguments. Okay, thank you for indulging me there.
Thank you, John.
Mr. Chairman, I'm sorry.
May I speak? This is Amy. May I speak?
I'm sorry, Amy, is that you?
Yes, may I speak, Len?
By all means, please.
Okay, so a few comments. Well before I was a member of this board, it appeared to me just from general scuttlebutt and information in the newspaper and so on that the the zoning was being rewritten in order to foster a certain kind of vision that some members of the community vociferously supported. But I don't think that it was appropriate for this particular parcel. For one thing, it's simply not a big enough parcel to support what John just referred to as a traditional village character. It's simply too small and too separated from the village. The MSMU zoning that envisions a second story presumably does that, from everything that I've heard, in order to encourage this traditional village character, walkability, density, but this is not actually a walkable area. When people walk to a cafe, the post office, the library, that's one thing. But to get to this place, they're either going to speed up on a bike, or they're going to drive and park near their destination. And then when they're done, they're going to drive away, which is different from traditional village character. And one other thing that I'd like to add, I agree with the applicant's presentation that to put a second story on there because of fire code and other things would require taking up so much space that there would be a very small use of that second story. It's inefficient in energy use. You know, basically there would be a heated area that's mostly taken up with staircase, elevator, fire safety, and it wouldn't really be used. And I think it would be offensive to put in there affordable housing. I think that's a very unwise plan. People who need affordable housing are the people who are least likely to be able to hop in their car and go whenever they need to get a prescription filled, a quart of milk, anything like that. And certainly the elderly, the disabled, families with young children would have a half-a-mile walk from that area to the medical office, the pharmacy, the supermarket. It's simply a bad place for any kind of housing, but particularly affordable housing. So I think this is a wise use of this parcel, and it doesn't bother me in the least that not every arrangement is made. Of course, the applicant can't, for instance, get Empire State Trail approval for the restroom and additional signage because they don't have approval for their parcel yet. But I see no reason why this couldn't proceed in a very normal way. Our job is simply to give a variance, and I'm going to vote in favor of the variance.
Thank you, Amy. Catherine, do you have any commentary you'd like to add?
I do.
Okay.
Essentially, in reviewing the balancing test and the factors under our consideration, I agree we have a limited scope. In looking at those 5 questions, this is clearly not a self-created situation. I do have some concerns about the feasibility requirement or feasibility assessment that was submitted to us that John outlined his concerns about. And I further agree with John that I think this is a substantial request. We're going from 2 stories to 1. That is substantial in my opinion. I will keep my total commentary brief. John, I think you did a great job in summarizing, and I say I would agree with 95% of what you said.
Okay,
So in
Steve,
summary, sorry,
Sorry.
just in summary, I am not in favor of granting a variance.
Stephen, do you have any questions or comments?
No, nothing at all.
Okay,
May I respond to some of the legal issues raised?
you were next. I'm going to catch you next, Catherine.
So what I heard respectfully from John was that you have to look at the stated purpose of the zoning code, the intent of the zoning code, that we have to bring projects that conform to the code. None of that is relevant to this board's decision whether to grant or deny a variance. That is the opposite of why applicants come before this board. They don't come to this board with conforming projects. There would be no need for a zoning board if every project conformed to the code. So the intent of the zoning code, that's not legally relevant in this board's consideration. And I think that if you go down that path, you're setting yourself up potentially for a decision that won't be upheld because you're applying the wrong standards. You know, we were accused of cherry picking, and 3 examples were made that, you know, we didn't have an opportunity to even respond to in the public hearing. I would have liked an opportunity to respond to that, but clearly we showed you 14 examples similar to what we're proposing. That's the character of the neighborhood. You may argue that this is a substantial variance, but the courts have held that even when there is a substantial variance, it doesn't matter, and zoning board's decisions to deny that variance request were arbitrary and capricious when the character of the neighborhood was consistent with what is being proposed. Here, the character of the neighborhood is consistent with what is being proposed. That is not really in any real dispute here. And you may have questions about the feasibility, but I didn't see anything in the record to dispute any of the statements by the experts submitted before this board. Was there another expert testimony that we saw that was submitted that disputed what we provided? There wasn't. There was, you know, a general community opposition, which really this board cannot consider. This board has to consider the expert testimony. There is a comment that one planning board member made a comment, and you can't rely on what one planning board member said. I would just like to remind the board that the majority of the planning board granted the waiver. So obviously that shows that they were in, the majority of the planning board was in favor of this proposal. And then finally, I keep hearing this discussion about affordable housing and residential development. Again, the first thing that this board is required, shall consider, is the benefit to the applicant. My clients are not residential developers. There is no benefit to my client to develop residential development. That's not something that they could consider. That's not a benefit to them. So that whole discussion is really irrelevant to the variance point. So I would ask that maybe you confer with your counsel about the appropriate standard that can be considered by this board, because in all due respect, you're headed down the wrong path if you apply the standard that John, and I apologize not having your name on the screen, John suggested, because it's contrary to what state law requires. And I think potentially you should speak with your counsel about the appropriate standard that this board must apply in considering an area variance.
Can I just say one thing quickly?
Hold on 1 second, John.
Yep.
Joe, would you comment on that, please?
Well, number one, I don't disagree with what counsel has said in terms of the state of the law. I have to say to the board, she's right on the case law. It goes back, I think, to what I said earlier in the beginning. It's the benefit to the applicant. This is not whether the law is a good law, whether its intent was good, whether its intent was bad, whether the project is good, whether the project is bad. Applicants come before the Zoning Board of Appeals to seek relief from the way the law is written. And I think the point that's being made here is to say the law is clear about what it says and what it requires, and therefore that law should be followed, does not really get to the heart of the issue facing the zoning board of appeals. It's true. People, everyone, whether it's a fence variance, a pool variance, this type of variance, comes to obtain a benefit, something that the law does not provide. They want a benefit. And that has to be weighed against not just how the law is written or what was intended or what might be best or what might be beneficial. It's whether there is a true detriment to the health, safety, and welfare of the community. Not a detriment to the law the way it's written, that, gee, this would allow a variance. It's exactly what the zoning board of appeals is obligated to do, be the safety valve as with respect to how the law is written. So your job is to weigh that benefit to the applicant against the detriment, if any, to the health, safety, and welfare of the community. So for instance, if you apply what the courts have applied, you might look at this from saying, is there a detriment, would there be a detriment to the neighborhood appearance if this variance were granted? You remember at the beginning I said, a lot of times what has been considered have been neighborhood appearance, adverse effect on property values, loss of tax revenues, decreased enjoyment of neighboring properties, traffic hazard. So one question might be, and John, you've given this obviously a lot of thought, would there be a detriment to, let's do the first one, neighborhood appearances, if the variance were granted? A true detriment.
My answer to that would be yes, because this new zoning is intended to create a character of a new neighborhood that is not yet really in existence. It is specifically meant to replace and become better and improve upon the character of the surrounding neighborhood. So,
but John, you're talking about what the law says that we want to do. And what I think that Joe is saying is the ZBA is here to grant relief from what the law says. Whether we should grant relief or not is the question in front of us.
And my argument is aimed squarely at a reason why we should not. It's a detriment.
It's a detriment to a zoning law that hasn't created a neighborhood yet. That's not the standard. The standard is the character of the neighborhood now. You're going, with all due respect, your answer to the question would not hold up in a court of law. How you just answered that question is exactly what would be stricken by the court if you were to apply that standard, because that standard that you just cited violates New York law.
Well,
that's not what you're supposed to do, is apply the intent of the zoning code. That's not the standard. And you could ask your counsel.
So what is the character of the neighborhood?
It's what we presented to this board to show you the existing one-story commercial freestanding buildings. You came up with 3. We provided 14. We've established that the character of the neighborhood is one-story freestanding commercial buildings.
Well,
it's not that we'd like to see in the future 2-story commercial buildings. That's not a basis. What your design goals in the future are not a basis to deny a variance requested today. That's just not the standard. It's not under any interpretation of the law. And you're making an error by citing that.
Well, I go back to my point about your kind of incomplete characterization of the surrounding neighborhood. You talk about a number of buildings, 14, great. Let's look at the square footage of the existing 2- and 3-story businesses that are adjacent to that. It's substantial. There are successful 2-story businesses operating in that very area.
But John, that has nothing to do with the health, safety, and welfare of the neighborhood as affected by this proposal.
Will there be a detriment, an undesirable impact on the character of the neighborhood when there are 14 similar type developments surrounding? It's not like you're saying there's no, you've admitted yourself, there's not like you're saying there's no other developments that look like that. There's a substantial number of developments that are exactly the same as this. The fact that you'd like to see something else in the future based on the intent of the zoning code, that's not a basis to deny this variance request. There is no undesirable change in the character of the neighborhood by introducing further one-story developments when there is substantial one-story developments in the neighborhood.
Well,
That's the reality.
I disagree with that whole concept, but I'm going to leave it at that for now. I still stand by all my arguments regarding substantiality, regarding lack of factual evidence. You know, your expert testimony, basically you have an opinion, you asked another person for their opinion. They gave it. No evidence, no
We
example.
didn't hear any other opinion in the record, though. We have to base our decision on what's in the record. I didn't see any other expert testimony in the record.
I don't need to provide expert testimony. I'm just saying, where is yours?
I think that would be erroneous to accept your own expert testimony over an expert that we submitted. You're allowed to weigh the balancing of two experts. That wasn't the case here. There's no other expert testimony.
I don't offer any testimony. I'm asking you for your testimony. I don't see any.
And we provided it. We provided expert testimony.
Those
You
are
didn't raise any. I didn't see any questions raised about you didn't ask for any follow-up information from our expert. We would have certainly provided it.
Catherine, could you just let the board know in what form was that presented?
In what form was what? The expert
testimony
presented?
Your expert testimony regarding the feasibility. I mean, I know there was a letter at some point to you.
Great. So we submitted with our January 26, 2021 submission a letter from a professional consultant and leasing broker advisor, Shannon E. Older, providing that it's not financially viable to construct a second occupiable story above retail commercial space. You also heard testimony in the record from my client, Ari Freilich, who's developed and managed retail commercial buildings for decades. We also provided, in response to the county's absurd, suggestion to create second floors for aesthetic purposes only, and that responded from the engineer that it's not, it's not financially viable. It would be cost prohibitive to undertake such a construction. I think, as I said, we're not constructing movie sets. It would be cost prohibitive to do that. So you've heard expert testimony from, there's no other expert testimony in this record to refute the findings of our experts.
I question what those findings are. I heard somebody express some opinions saying they have encountered hesitancy. That means nothing. There's no evidence, no studies, no examples.
I don't think that we've said that. I think our letter provided specifics, and there wasn't a question raised in the record, and there's only one expert testimony that's been submitted before this board.
Well,
may I just speak for a second here? This is Amy. It seems to me that we know, even without experts, that if there's a second story, there have to be two means of egress from the second story, and there has to be a hall of a certain length, and it simply stands to reason that that cuts way into the amount of usable space that's going to be on the second floor for, I don't know, a dentist's office, apartments, whatever it is that could be put in there. It's only going to be something like 50% of what would be on the ground floor. So we're not talking about a significant benefit to the community of filling up all this extra space. In fact, on Main Street, there seems to be too much extra space right now because of the pandemic. And I don't think it takes an expert to say that's not going to be very useful space on the second story. I'm willing to go out on a limb and say that's going to be hard to get a reasonable rate of return on that.
Amy, you are expressing your personal opinion about this. Wouldn't you like to
Yes,
have,
I am.
wouldn't you like to have an expert provide you with some actual information based on real world data?
Well, John, there are some things you don't need to be an expert about. I know, without being an expert, that if you're going to put office space, living space, whatever, on the second story, you're going to need two means of egress and a hallway. And we don't need a consultant to tell us that.
We might
I'm
need,
perfectly willing to.
we might need a consultant to tell us financially what are the actual consequences.
And, you know, I just want to point out in this code, you can't have a more than a 7,500 square foot footprint. So we're already dealing with a building that's restricted to a 7,500 square foot footprint. So it's not like we could create, like in the original proposal, a 13,000 square foot CVS with another story on top of it that you may be able to lose some space on the second floor. We're already constrained under the code to 7,500 square feet. So it's not feasible to create a usable second floor with those constraints that the code already provides. Just not.
And the proposals that I heard from the community, in addition to affordable housing, which I think is a terrible idea. Why should we stuff the people who need affordable housing into a corner where they're going to have to walk a half a mile to get to anything, and where they're next to the noise and light of the highway?
Amy,
In addition to affordable housing, the other suggestions that I heard were things like a bowling alley. I just don't think that's feasible. I recognize that's my opinion. I think it's also common sense.
but Amy,
I don't need an expert to say no bowling alleys can fit there.
I would like to lay this to rest once and for all. Nobody's talking about affordable housing. It's not part of this proposed development. It's not an issue.
Good.
But
Okay, well,
this development or project is also not the issue. Whether it's good for the town, bad for the town, who likes it, who doesn't like it. That may have been for the planning board when it was thinking about giving or not discretionary waivers for certain things. It may have been the criteria that the town board relied on when it considered those waivers. Oh, we want our law enforced. The job of the zoning board of appeals, again, I don't mean to sound like a broken record. Your job is very different than those boards. There is a statutory and there is a case law means by which this board is supposed to judge every application, as I said, not just this one. Somewhere I need to hear somebody address those issues about if this variance were to be granted, will there be a detriment to the health, safety, and welfare of the neighborhood or the community? That's the standard. And if if you're involved in zoning board litigation before a court, that is exactly the standard that the court is going to hold the zoning board of appeals to in that proceeding. So I think I would like to hear the board members address the detriments to the health, safety, and welfare of the community if this variance were granted. True detriments.
Detriment to the welfare of the community.
Health, safety, and welfare of the community.
All right,
True
detriment. I won't argue strongly about health or safety here, but welfare of the community is embodied in our town code, including the zoning code. We try to set up the town in a way that favors the best possible town for the highest number of residents, trying to establish what we want our town to like, how we want it to grow, what is going to be beneficial in the future, ongoing for the community. So to completely defeat the purpose of the law set up to do that has got to be considered detrimental to our community welfare.
But John, we're not the people who make that.
Is not to enforce the zoning code as it is written. This board hears applications by applicants for relief from that. And as I say, whether it's a pool, whether it's a fence, whether it's a side yard setback, if you have to gauge it from the standpoint, not that it doesn't agree with the way the town board wrote the law. The question is whether or not the granting of that variance will create a detriment to the health, safety, and welfare of the community. I didn't write that.
I just tried to say as much, and it's not because it contradicts the way the law is written. It's because in application of that law and its effects down the road, that is going to be detrimental to the welfare of the community.
What we want.
I don't think we're allowed to consider down the road.
Down the road.
We have to look at this application.
Yeah.
Yeah, the quote was what we want our town to look like. What we want our town to look like is not a detriment recognized by law that any court would uphold. It's not. And to say that it completely defeats the purpose of the zoning code when the project complies with 30 plus requirements of the zoning code and doesn't comply with just one, that's also a bit disingenuous. But really, the standard that you're seeking to apply is erroneous under the law, because you're looking at what you want the town to look like down the road, or what you want the code. I mean, then nobody would ever be granted a variance if that were the standard, because the code is the code and the code says what it says, but that's not the purpose of the zoning code, a zoning board.
We are perfectly free to grant you a variance if you meet all the requirements. And
I wouldn't need a variance then.
Sorry?
I wouldn't need a variance if I
You
met
get
all
a
the
variance when
requirements
you
of
don't
the
meet
code.
the requirements.
I understand that. I understand that perfectly well. I'm talking about, should we grant a variance?
But the standard that you're proposing that the board and one member in particular seems to be following is erroneous. It's not the standard that the courts have recognized, and it's not the standard under state law. You've proposed standards that directly conflict with state law.
All right, well, let's leave that aside for the moment. It's not the only one and only standard. There are 5 questions that needed answers. I've provided contradictory points to all of them except the self-created, which I let go. But you're still in the majority of those questions, insufficiently supporting your arguments. I still am looking for factual evidence on any of this stuff.
If we could continue with the questions that your counsel was asking.
Yeah. Well, again, my recollection is that there was a fair amount of information that was submitted that addressed those issues, the feasibility, substantial, the economic interest, and the rest of it. I mean, that's my recollection. My recollection is also that I don't know that there were any submissions by members of the public that were contrary or refuted the information that was submitted by the applicant. That said, the board members are free to go back and review, if they want, what was in the record. We certainly can't require any new information now. Public hearing has been closed. No new information can be requested.
I'll just say,
amongst the other issues, I'd ask this: if the variance were granted, would there be an adverse effect on property values. Yes, as part of that health, safety, and welfare component, does anybody have a view on whether or not, if this variance were granted, it would have an adverse effect on property values?
Joe?
Yep.
I don't see any development, new construction having an adverse effect on any of the other property values there. At the present time, across the street, there's a hole in the ground filled with cattails and overgrowth. From the presentation that has been submitted with regard to the plan of the design, I can't understand how conceptually that would have any adverse effect on any of the properties around there. At the present way that the property is right now, it's a liability. Even though those large ramps are there to protect anyone from going over, the present state of the property right now, I believe, has much more of an adverse effect on the quality of the neighborhood than a developed, well-graded, maintained property as it's been presented to us. Anyone else?
Others?
I would just want to ask, Joe, when it says welfare of the neighborhood, does that include the fact that the project would provide some jobs?
That's, again, you're into, Amy, the project itself and whether or not it appears to be a good one, a bad one, etc. Will it provide jobs? The issue here is this particular variance, this applicant wants to avoid those design standards that requires a second story. That's the issue. And whether or not this project provides jobs or not, for all we know at the hands of the planning board, perhaps this project never gets approved, it never gets built. That's speculative. One of the questions might be the inverse would be, is there going to be, for instance, a loss of tax revenue to the town as a whole, such that that creates a detriment to the town if this variance were granted?
Thanks, Joe. You always keep me on the straight and narrow. Thank you.
My job here is not to lead you to one answer or the other, but my job is to make sure that the board knows and understands the difficulty that it has with an application such as this, to make sure that the record is protected and preserved, and that the standard that's applied in this case is the same standard that is applied in any other case that comes before this board previously or after this. This is the standard. This is the tough job of the zoning board of appeals. Not a tough job of the town board. It's not a tough job of the planning board. It's a tough job of the ZBA because you have a very strict set of standards.
Catherine, any commentary?
And
I'm going to say,
then you balance these issues. And I would just add, you needn't find in the affirmative on every issue. You don't have to find each issue. You might, for instance, say this, in our view, was self-created, but when weighed against all of the other issues on the balancing test, that's not sufficient to deny the variance we request. You might say it's substantial or it's middle of the road substantial, but when weighed against everything else, it is not that you can say when weighed against everything else, the variance should be granted. So you don't have to find each of those 5 items. You have to balance those 5 items in coming to your decision about the benefit to the applicant and the detriment to the community. I just wanted to make that clear.
I want to say one more thing, and then I'll stop. The one thing the law is very clear about is that decisions must be made on the basis of factual evidence. And again, assertions, opinions, entreaties, none of these things count. And I think it's very telling that in the face of experts who've been consulted and people with years and years of experience and stature in the field, with all that in hand, nobody could come up with a single example that would provide a fact for us to take into consideration. So I'll leave it at that.
So I just want to.
Maybe my recollection of what was in the record is different. Maybe the board members want to revisit the submission that was made by the person called upon by the applicant. Catherine, I'm sorry, I stepped on your comment.
Joe, I just want to appreciate your input. Actually, it was highly clarifying for me when weighing the balance test as opposed to answering no to all 5 questions. So I think that welfare is where we get a little bit tied up here. You gave specific examples of how that is defined. And when it comes to property values, I do not see a detrimental impact. And I think where we're caught up is in character. At least that's what I'm hearing. And we have a pretty diverse character in this zoning district, ranging from 1-story to 2-story across the board. So I think that that's something for the board to consider. But as far as the balance test goes, I'm starting to lean in the other direction. So I appreciate the robust conversation. It's very helpful to hear how that balance test should be factored into when I think this is substantial. However, in evaluating that welfare definition, I'm leaning the other way.
So through Joe's commentary, we've been advised that it's a balance. It's a balance. It's a balance. With the benefit to the applicant and the detriment, or comparing it to a detriment to the health, safety, and welfare of the community. Not every one of the 5 questions needs to be answered specifically satisfactory. It's like if you get 1 question wrong, you don't fail the test. From what Joe has told us, and as best as I can understand, if there's one we don't agree with, but all of the others we would agree with, then you pass the test. And in this particular situation, it's been pointed out many times through a lot of discussion that not every one has been answered wrong by Attorney Zelantis. There are members of this board that may not agree with everything she said at one point or another point with another question, but I do believe that most of the answers provided provide an adequate measure for us to make a determination. Anyone else like to speak?
No, that sounds
Amy?
sounds good. I think we should. I think it's time to, bearing in mind everything that you said and that Joe said, I think we should proceed and answer the questions.
Okay.
You're going to need a resolution first.
Okay, help us out with this, please, Joe.
Well, Len, you wrote a submission or had something in writing. John had something in writing. Does someone want to put that submission in the form of a resolution and include the deliberations of the board here this evening relative to the record?
So the letter that I first read in the beginning, you would refer to as the resolution, Joe?
I suppose you could put it into the form of a resolution. I think if you were to do that, I think it would be beneficial to include in it that it's additional, in addition to your thoughts, that it is supported by the record and supported by the deliberations of the board, and see if the board ultimately agrees. They may wish to add things, subtract things to your resolution, but you can get something on the table.
Okay. Do I need to read that again?
Maybe you should just sort of hit the highlights, put a whereas in front of each highlight.
Okay. I'll
Yeah,
do that.
let's get it on the record, Lynn, in the form of a resolution.
Okay. Okay, I'd like to make a resolution with regard to the granting of the variance for the Trans Hudson property under the following resolution. Whereas the decision of the board is to weigh the benefit of the applicant against the detriments of the community with regard to the 5 questions asked on the area application. It will be the decision of this board to determine if there is or are health, safety, and welfare community issues. Whereas,
Would it be possible, Lynn? Oh, I'm sorry.
Go ahead. What was your question, Amy?
I was going to say, instead of saying it will be the decision, could the motion say either whereas we find this, we ask that the applicant, we order that the application be approved or be disapproved, rather than referring to will make a decision. Is that possible?
Well, I'm going to add the information as to some supporting information as to how we're going to get to that decision.
Okay. Sorry, I interrupted.
Whereas drive-through request has been removed and the area variance is seeking relief from the 2nd-story requirement as defined by the MSU, Main Street Mixed Use, and the BTU Bulk Table Use. That requirement requesting for 2 second-story suggested was for affordable housing. Okay. I can leave. Whereas the property owner has stated that an interior stairwell and hallways for entrance and exit and an elevator are not only cost prohibitive, but there is a large loss of usable floor space on the 1st floor. Whereas discussed at previous meetings, being adjacent to the New York State Thruway, there will be excessive noise from cars through exhaust fumes from engines, making this not a desirable location for affordable housing. Whereas this location is not in a residential area, residential homes are approximately 1 mile down the road. Whereas with regard to the traffic, this application was in front of the planning board years before the land for the fire station and police court building was even purchased. Whereas this application is requesting less density than was initially required on the initial submission. The part about the landlords and the overflowing stuff, we'll leave that out. Whereas the developer has met many of the requirements, almost 30, except for the affordable housing.
Except for the 2nd story.
Except for Len, consider consider except for the second story. Because I don't believe there's an affordable housing component in the
Okay.
statute.
All right.
But I think it's intended that they've met, you intend that they've met them with the exception of the second story.
Whereas the Ulster County Planning Board made a suggestion to build a second story for aesthetic purpose, this is not a practical and cost prohibitive. Whom will it benefit?
Is that something which is in the scope of our review, Len?
I'm going over some of what I wrote down this afternoon. Whereas this agreement is supported by records and deliberation of the boards, of the ZBA, in town of New Paltz. Any suggestion to add, Joe?
Len, go back if you would to about where you addressed about the Ulster County Planning Board. There was a sentence at the end that sounded like a question in there. Who would this benefit or
Who
something?
will it benefit? Lee, cross that out? Yes.
Or if you want to phrase it in a different way. I mean, if your intention is to say that such a suggestion should not be followed as it would not benefit anybody, that's putting it in the affirmative, if that's what you mean.
This suggestion provides no benefit to the applicant.
Len,
Yes.
Len, I would like to suggest that you just go back and take out language about affordable housing. It's just not germane.
Joe?
Yeah, I had a note on that too. It really is. I don't know where that appears in your draft.
Okay, I got it. That's out.
Put up in a couple of places.
Okay, I've gotten rid of all of the. Okay.
Joe, is it necessary to have all of our reasons in there or just a some of the reasons?
Well, the more reasons you can put in there as to why this meets or does not meet those 5 criteria, the better it would be for the record, certainly.
Okay, please, somebody else, add.
How about, and you may have already said this, Len, but how about, whereas we find that the proposal offers no detriment to the health, safety, or welfare of the neighborhood or community. Did you already say that, or is that?
No, I'm writing it down.
Okay. And Len, is it necessary to have another whereas that says that on balance, we find that the benefits outweigh the detriments, or is that going to be obvious from?
Nothing's obvious. In balance.
That the benefits to the applicant, whereas we find that the benefits to the applicant outweigh the
outweigh.
No,
outweigh.
I'd like it not to go in that direction.
Okay.
I think you were right. I think you were right before where you said, I think you said that you find that the benefit to the applicant Was it offers no detrimental or no detriment to the health, safety, and welfare of the neighborhood or community?
Okay,
Okay,
That was
All
in the
right.
very beginning.
and then maybe you might add, whereas in making that determination, the board has found and determined
can we just say the board grants the applicant the
well-
relief requested?
well, no, then I go down through, then I think you go down through the 5 criteria. If you say
Yep.
the board has found and determined, one, if this is what you're going to say, that there will not be an undesirable change in the character of the neighborhood or a detriment to nearby properties. In other words, almost basically follow the 5 criteria. 2, that the board finds that the benefits sought cannot be achieved by some method feasible to pursue. I mean, and go down through them in order.
Okay, let me do that.
And then whereas based on all of the above, the board finds and determines as follows. And I would say that we need to leave room at some point, of course, that the variance is, if it's granted, would be conditioned upon ultimately site plan approval by the planning board as required.
Isn't that sort of a catch-22?
Well,
We can't grant them,
No,
well,
the planning board cannot move forward until this decision has been made.
right, but I think we talked at an earlier meeting, Catherine, forgive me if I'm wrong, I think we spoke about that there would be something that the granting of the variance, one of the conditions of it would be that approval of the plan in substantially the same form has to be approved by the planning board, right?
Yes, we intend to present this plan so that you'll be protected, that what we're proposing here is consistent with what we're proposing before the planning board. You know, subject to the planning board's making changes to the plan, because I'm sure they're going to further refine the plan and make it better.
Right, it's going to require a final site plan review by the planning board.
But it'll be in substantially this form, subject to any changes and they require.
I'm writing.
well, Len is writing, just so we're clear, Joe, are we granting or denying this variance as it stands in front of us today? And then if there are changes, that's something for the site plan review. Am I correct?
Well,
It seems to me that we have to give
if the
our
variance,
decision.
if the variance is granted, really the only thing that would be granted is the fact that the design standard and the architectural standard for a second occupiable story,
Right.
that a variance from that has been granted. That's it. I mean, it
That's the
really
only thing on
doesn't,
the
it really
table for us.
doesn't go to the plan, the ins, the outs, the traffic patterns, driveways, parking. Goes to Catherine, right? It goes to nothing about that. This
Right,
is
so there's-
solely to the second story.
Right, and there's actually
So
two
there's nothing
variances.
conditional.
I'm sorry, Amy?
There's nothing conditional about it, right?
No, it would grant the relief that basically the planning board would be looking at a plan that does not have to have a second occupiable story by virtue of the granting of the variance. Catherine, would you agree?
Yes, it's two variances, one from the bulk, one from the design standards. Both are related to the second occupiable story. So the plan that we can present then to the planning board would not have the second occupiable story in it. It would be deemed zoning compliant, but, you know, like I represented previously, the variance approval would be conditioned upon us going back to the planning board and getting site plan approval on the plan that we presented to the board, subject to any changes that the planning board may require in its review process as part of the site plan approval.
Right, it really can't tie the planning board's hands in terms of site plan issues. It would go only.
Right. I'm just trying to avoid a catch-22.
No, we are not the planning board.
Right. So if we grant a variance, then we've done all the job that we have to do. There's nothing conditional about it.
That's correct.
Correct.
Okay.
The applicant, I think, would proceed with their site plan application before the planning board with the variance in hand if it were granted.
Right.
Okay, the other things that I've added to this, if I may, whereas in making this variance determination, the board has found there will not be a detriment to the community, whereas the benefit to the applicant cannot be achieved by another feasible method, whereas this request is not substantial, whereas this request was not self-created.
Sounds good.
So
therefore,
How about yeah, Catherine, you raised your hand.
I think we skipped over the fourth one about.
Which one did I miss?
Oh yeah, whether it would have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district.
You're correct. Whereas this variance request will have no adverse effect on the character or environmental conditions of the neighborhood. Okay. 1, 2, 3, 4, 5. Yes, they're all there. Okay.
okay. Are we ready for, therefore, be it resolved that the zoning board grants the applicant's request for relief?
We have to vote.
Yeah, but that needs to be part of the resolution. You left out the meat of the resolution.
Yeah, that would be part of the resolution.
Therefore, we grant. Amy, go ahead.
Oh, therefore, be it resolved that the zoning board of appeals.
Oh, I can't write that fast. It'd be.
Okay, ZBA. Be it resolved that the ZBA grants the applicant the area variance relief as requested.
Joe, you recommend we do a roll call vote on this?
Yes.
Okay.
If you're going to say that, I think you should say that the applicant, it grants the applicant the area variance from the.
With relief.
That it grant the applicant the area variance requested from the bulk standards and design standards with respect to a second occupiable story. Catherine? Okay,
Thank you.
we want to make it clear that it's,
Right.
that's what's being addressed, the design, the bulk requirement variance and the design requirement variance.
Leonard,
I'm writing.
I'm not asking you to write.
Yes.
Before you said not a lot of unusable space on the second floor. Instead of you said the first floor.
That's right. If the building required what is required, an entrance and an exit and a hallway and an elevator, it would reduce the amount of usable space on the first floor. So it is a detriment to the first floor.
Yeah, you said the first floor. Yeah.
Okay.
Okay.
I'll get that corrected. Thank you, Steve.
Gotcha.
Okay.
Call a vote?
Okay, at this point in time, at 9:09 on June 9th, I'd like to take a roll call vote and make a recommendation for the granting of relief from the bulk standards and design standards with respect to the second floor story. I vote in favor with a yes. Amy?
Yes.
Catherine?
Yes.
Steve?
Yes.
John?
No,
Thank you. 4-1. Okay. I guess the next real question, well, it doesn't really matter now, because we have a majority plus one. So that is an override of the county. I thank you all for your information and your help with that. And I guess the next item on the agenda, Alana, I will get this paperwork. Are you in the office tomorrow?
Yeah, I am. I tried to transcribe what you were saying as best as I could, but if I had your notes, I could make sure that
I've got to rewrite my notes so you can at least
Okay. I was trying to type word for word, so hopefully I'm pretty accurate.
Okay, all right. Mr. Freelick, you have a question?
No, Mr. Chairman and board, on behalf of the applicant, we thank you for your patience and diligence in this.
Thank you. Have a good night.
Thank you,
Oh,
Mr. Chairman.
Leonard.
Thank you, members of the board.
Thank you, Ms. Stellantis.
Good night.
Okay,
Good night.
has Christopher Schmidt come? Yes, Christopher, did you have any luck?
Yes, I did, Mr. Chairman. I found two items which I had sent to Alana, who she has forwarded, I believe, to everybody on the board.
Okay,
The first item, first, I do apologize for having the incorrect information on there. I made an assumption of using the Westchester County health setbacks as New York State due to their reference to the New York State Code. However, in the research, I found that the New York State on-site water treatment handbook recommends a minimum distance of 35 feet for ground, further if possible. 35 feet is also stated in the New York State DEC manual for on-site wastewater treatment.
May I just interrupt to say I have Alana forwarded a chart, but there's no headings on it. So I see the number 35 at one point. Swimming pool
Yes,
and ground, but it doesn't, from what to what? Can you put a heading on it?
Yes, I sent the chart and then a link to it. It's table B2 for minimum horizontal separation distance in feet. The table is too large to send. and see in one screen. It's on 2 pages of the manual. So the 50
Okay,
feet
so it says,
distance from the absorption field located in gravel soils.
so where it says swimming pool in ground, 35, that's supposed to be 35 feet from the edge of a swimming pool or the edge of the paving around it
It's
to
the
edge of the
swim-
septic system?
The edge of the swimming pool itself.
Okay, to what point?
To the leach field, to the absorption field.
Okay, to the nearest pipe in the absorption field or the excavation? What does it refer
Yes,
to?
Stacy,
I'm sorry, I can't hear you.
you muted, Stacy. Stacy, you're muted.
I would
Can
say,
somebody else relay what's being said?
I'm here, Amy. I would say not to the pipe, to the absorption area around the pipe.
Okay.
Okay.
And is that located on the maps that we have?
Yes.
He has located on the map, and I have to tell you, I was out there, and when I was out there, the absorption field was clearly visible. I don't know if, sometimes you can see where you can actually see where the fields are and the pipes are, because the grass is green and you see lines in the yard. And his map is accurate.
Okay, I'm sorry, I must be having trouble with my phone. I'm gonna excuse myself and try to sign in to regular Zoom. Alana, could you let me in?
Yeah.
Thank you. Bye.
Forgive me for a second.
Alana, did you receive the documentation with the proper heading that you needed to validate it? Validate it?
Yeah, they have headings.
Okay. So Stacy, that information is now acceptable?
I would say yes.
Okay. Okay. Let me make sure I have the right folder here. Yes, Outlook Farms. Okay. We've gone through the 5 questions. We were waiting for and so we need to entertain a motion to close that public hearing for 19 Outlook Farms. Seconded by Stephen. All those in favor signify by aye. Aye. Motion. Okay. Public hearing is closed. So I need for someone, if they would, to entertain a motion to accept or deny this variance. Stephen makes a motion to accept the variance. I need a second. I'll second that. All those in favor of granting the variance for the swimming pool at 19 Outlook Farm, please say yes. Raise your thumbs. Yes. Stephen, yes from me. Catherine, yes. John Gatto,
No.
and where is Amy?
I'm in the meeting. I say no.
Amy says no. So we have 3 yeses. We have yes. Len, Steve, and Catherine. No is John and Amy. Motion carries. Okay. Any other business on this meeting night that anyone needs to discuss?
I just wanted to say thank you for giving me the opportunity to correct that and find that information, Mr. Chairman.
Okay, you're very welcome.
Have a great
Another
evening, everybody.
one more month for you to get started.
I appreciate that. Thank you so much.
Okay, thank you.
Bye-bye.
Joe, you have a question?
Len, I have a question. Alana, you're still there, right?
Yes.
I just thought of it. I'm assuming that 4th of July weekend, town hall may be closed. Is Monday?
Monday.
4th, okay. Does that present for this board any problems with people who want to get on the agenda, make an application, the rest of it? Because they must have to be submitted so many days in advance, right?
You have to pull up the submission thing. Hold on.
And I'm just thinking if our meeting is the, what'd you say, the 14th?
Our meeting.
My apologies, I asked the question without a calendar.
It's the 14th.
Okay, it's the 14th.
The submission deadline for new applications is June 30th for the July 14th meeting. Is that what you're asking?
And, okay, and town hall would be open on the 30th. Yes, Stacy says yes.
I'm assuming, yeah, I don't know why it
Okay,
wouldn't
all right.
be.
Okay, well, I'm just asking.
Okay.
Okay. So I guess this time I'll entertain a motion to close the meeting.
So moved.
All those in favor, and I'll say, seconded by Stephen Esposito. All those in favor signify by aye. Yes, yes,
Aye.
yes. Motion closed. I thank you all for your time this evening and stay well. We'll see you in another month.
Thank you.
Thank
Thank you, Joe.
Thanks all.
Okay.
Stacy and Alana.